welcome to this licensing hearing panel. Can I please ask for nominations for chairman? Thank you. Is that seconded?
Seconded.
Thank you. Councillor Mrs. Diane Chambers, you are now chairman. Thank you.
Thank you very much. Apologies for absence. I think all members are here. So can I check with members, can I sign the minutes of this meeting outside the meeting? Yeah. I have no urgent matters. Are there any declarations? Okay. Good morning. Can I just ask you if you all have the pack of papers for this morning, which will include, yes, the list of how the meeting will run. Yep. It should be in your bundle of papers if you haven't got that one. It's about the, it's on the back of the one which talks about fire and evacuation procedure. It's on the back of there. Yeah, okay. Right, so following that, we will introduce ourselves, and I'll go from my colleague, Councillor Brown.
Good morning. I'm Councillor Brown. I'm Councillor Sylvia Griffin.
Good morning, I'm Fiona Wilson, Environmental Protection Technician.
Good morning everyone, I'm Stuart Steed, I work for the Strategic Environmental Protection team.
Good morning.
Good morning, my name is Vlad. I live in number 42 High Street.
Morning, my name is Jamai Damawami. I'm here to support the applicant.
Good morning, my name is Kingsley Atoya. I'm the licensee.
Morning, Chair. I'm Graham Hopkins, and this is Linda Potter from GT Licensing Consultants.
Good morning. I'm Franco Di Fazio, Senior Licensing Officer.
Morning, I'm Laura Cowles. I'm the legal advisor to the panel today.
Hello, I'm Julie Francis Beard, and I'm the clerk to the panel today.
Thank you. Mr. Di Fazio, would you like to explain why we're here?
Has received a premises licence review application from Medway Council's Environmental Protection team as a responsible authority in respect of the existing premises licence for the Jollof Lounge, 44 High Street, Chatham, Kent. The grounds for the review relate to the following licensing objective: the prevention of public nuisance. The application has been correctly advertised in accordance with regulations made under the Licensing Act, and the application papers were served on the relevant parties for the licensed premises along with the other responsible authorities. In addition to the review application papers, representations have been received from Medway Council's Planning Department, Gravesham and Medway's shared licensing services, and members of the public in support of and against the premises. In particular, your attention is drawn to the following appendices. The review application is contained in Appendix A, which is page 13. A copy of the current premises licence with plans is in Appendix B on page 29. Representations from planning can be found in Appendix C, and that's on page 37. Initial representations from licensing can be found in Appendix D, that's on page 41, with additional evidence from licensing in Appendix E on page 43. Further evidence from the Environmental Protection Team is contained in Appendix F on page 49, and Appendix G contains representations in support of the review on page 127, and the representations in support of Jollof Lounge can be found in Appendix H. Submissions from Mr. Atwania in relation to the review from the premises licence holder can be found on Appendix I on page 135. I'd just like to mention that we have some representatives here that would like the opportunity to speak, and there are some audio files that will be needed to be played as part of the evidence. Thank you.
Thank you, Mrs. Fazia. Right. Good morning. I think it's Environmental Protection who are here to bring this case.
Good morning. My name is Fiona Wilson and I'm employed by Medway Council as an environmental protection technician. Part of my role includes investigating complaints of noise under statutory nuisance legislation. Statutory nuisance can be defined as an unlawful interference with a person's use or enjoyment of land or some right over or in connection with it. The process of determining what level of noise constitutes a nuisance is subjective, and several factors must be considered, such as the frequency, duration and the time of the noise. Therefore, when gathering the necessary evidence, officers must make a comprehensive assessment of how the noise affects the enjoyment of the property. When assessing a noise that may be disturbing a person's sleep, an assessment would be made from bedrooms, demonstrating the difference in noise levels with the windows open or closed. Consideration is also given to the climate conditions and any other background noise. I've been investigating complaints of loud music with heavy bass from the Jollof Lounge, also known as Lounge 44, since October 21. Lounge 44 is advertised as a restaurant, bar and grill serving authentic Nigerian food with a beer and shisha garden with a DJ every Friday and Saturday night. The establishment is situated mid-terrace within a row of designated and professional business uses, and there are residential flats located above the shops. Evidence of a statutory nuisance has been gathered, which has led to a formal notice being served on Mr. Kingsley Atawanya. The notice has been breached 3 times. The council is continuing to receive complaints regarding the level of music and bass emanating from the premises. On the 22nd of October 2021, a letter, which is FW01, was sent to the premises to advise that a noise complaint had been made and that the council was investigating the allegation. Mr. Atawanya was advised to consider if the complaint had merit, to take action to prevent possible noise nuisance, and that the council would be carrying out monitoring if further complaints were received. On the 11th of December 2021, a complainant contacted the council's out-of-hours noise call-out service to request an officer to visit to witness loud music emanating from the Jollof Lounge. Loud, bassy music was witnessed from a neighbouring property at a level that would disturb or prevent sleep. In the officer's opinion, the level of noise emanating from the Jollof Lounge would constitute a statutory nuisance. As a result of this evidence, a Section 80 noise abatement notice under the Environmental Protection Act 1990 was served to Mr. Kingsley Atawanya at his home address on the 14th of December 21. I explained to Mr. Atawanya at the time loud amplified music and bass was witnessed emanating from his premises, which was deemed to be intrusive. Mr. Atawanya informed me that he had double glazing and an acoustic report. It was explained to Mr. Atawanya that his report was based on a DJ playing background music. However, what was witnessed was a loud DJ set that continued into the early hours of the morning. His licensed hours at this time were until 23:30 hours. Mr. Atawanya stated that his music was turned off at midnight. Mr. Atawanya was then informed that officers were on site until 1 a.m. and the music was still playing. It was highlighted that Mr. Atawanya had been advertising events on social media. However, there had not been any temporary event notice applications for these. He stated that they were not events. It was recommended to him that he may want to consider that these events could breach the notice that is now in place. Mr. Atawanya was made aware of the appeals information provided with the letter and notice, and that our monitoring would continue. I advised licensing that a Section 80 noise abatement notice had been served to the premises and asked whether there had been any temporary event applications for the 11th, 18th and 26th of December 2021. As Lounge 44 social media was advertising entertainment in the form of DJs taking place until 2:30 a.m. and dawn, which was outside of their licensed operating hours of 23:30. Licensing spoke with Mr Atuanyu on the 16th of December 21 to advise that if he wished to have entertainment past his operating hours, then he would be required to apply for a temporary events notice. An application was submitted by Mr Atuanyu for an event on the 26th of December 21, but it was objected to by Kent Police's licensing team. On the 11th of January 2022, Mr Atuanyu applied to vary his licence to extend his opening hours on a Thursday till 1 a.m. and Friday, Saturday until 2 a.m. He also wanted to remove the substantial meal with alcohol. Mr Atuanyu was advised by the Environmental Protection Development Team that the acoustic report submitted for his existing licence was not adequate for the proposed enterprise. The application was subsequently withdrawn. On Saturday, the 26th of March 2022, a complainant contacted the Council's out-of-hours noise call-out service to request an officer to visit, to witness loud music emanating from the Jollof Lounge. Loud bassy music was witnessed at 11 minutes past midnight on Sunday, the 27th of March, from a neighbouring property at a level that would disturb or prevent sleep. In the officer's opinion, the level of noise emanating from the Jollof Lounge would constitute a statutory nuisance. It was therefore a breach of the Section 80 noise abatement notice that had been served. Mr Atuanyu was sent a warning letter on the 29th of March 2022 informing him that he had breached the noise abatement notice served on him. Mr Atuanyu did not respond until Tuesday the 23rd of May 2022, where he stated in an email that that was the day the clocks had gone back, which he had missed. He also wanted to appeal the notice that was served to him on the 14th of December 2021. Mr Atuanyu was clear in this being a vendetta against his premises. At this stage, I decided to arrange a visit to the premises to better understand how it's being operated and to discuss with Mr Atuanyu how statutory nuisance investigations are carried out. On the 30th of May 2022, Rochelle Roberts from the Animal and Environmental Protection Team and Franco Di Fazio from the Licensing Team carried out a pre-arranged advisory visit to the Jollof Lounge with Mr Atuanyu. It was explained to Mr Atuanyu the status of the statutory nuisance investigation and that if another breach of the notice was witnessed, we would be considering prosecution. Mr Atuanyu was also advised on his licensing conditions. However, he did not have a copy of the licence as he had returned it with the application to extend his hours. Mr Atuanyu explained that he had hoped to move the music and lounge area into the basement and keep the restaurant on the ground floor. The basement was derelict and Mr Atuanyu was awaiting approval of his planning application to extend his operating hours so that he could secure funds to carry out the necessary work. It was explained to Mr Atuanyu that condition 8 of his licence had not been met, which was his noise impact assessment. But it meant that he could play music until 11 p.m. But it was reiterated that although the licence conditions meant he could do this, it didn't mean it allowed him to cause a statutory nuisance. Mr Atuanyu formally applied to vary his licence on the 4th of August 2022, and he was given temporary approval by the Environmental Protection Development Team and Planning, as the recommendations within his recent noise impact assessment had included the desired measures for the provision of smoking areas and restrictions on the number of patrons allowed to leave to smoke, and suitable times in which to enforce this policy. They were satisfied that the noise impact assessment recommended as much as it could in which to limit the noise from the premises. It was the view of these departments that Mr Atuanyu should be given the opportunity to implement the recommendations set out in his noise impact assessment and demonstrating that by doing so he would not be causing a further nuisance. Between May 22 and November 22, further complaints of noise and Noise Act recordings were made by the complainant showing that there was a continuing disturbance from loud music. On the 12th of November 2022, a complainant contacted the Council's out-of-hours noise call-out service to request an officer to visit the loud music emanating from the Jollof Lounge. Loud bass was witnessed from a neighbouring property at a level that would disturb or prevent sleep. It was also noted that there were no door staff present at the time of the visit. In the officer's opinion, the level of noise emanating from Lounge 44 would constitute a statutory nuisance. It was therefore a second breach of the Section 80 notice served. I emailed Mr Atuanya on the 16th of November to inform him of the second breach of the Section 80 noise abatement notice. He was also sent hard copies of these in the post. He was then invited to interview under caution on Thursday, the 1st of December at 11 a.m. On the 22nd of November, I was also informed that licensing had issued a warning to Mr Atuanya due to there being no door staff present on the 12th of November. Due to Mr Atuanya being unavailable on the 1st of December, his interview under caution was rearranged for the 20th of December 2022. Mr Atuanya arrived for his interview and it was explained to him the interview was in relation to the breach of the Section 80 noise abatement notice. During the interview, Mr Atuanya submitted a prepared statement and he admitted to the following. On Fridays and Saturdays, he regularly hosts recorded entertainment in the form of a DJ. He is licensed until 2 a.m. However, depending on how busy they are, the entertainment may end earlier. They only play amplified music on the ground floor restaurant level on low volume. In August 2022, he applied to various licenses to increase his hours for regulated entertainment to the following. Thursdays from 2300 to 1 a.m, Fridays and Saturdays until 2 a.m, and Sundays until midnight. Prior to the above application, previous hours for his licensable activities under the licence ceased at 23:30 daily. The application was granted for the hours that are currently on the licence. He wished to point out that his application to extend the licence, including live music and recorded music, was granted whilst the notice was in force. He has a noise management plan in place for the premises. The plan has been prepared by Expert Acoustics, DAA Group, and forms part of the noise impact assessment, which was also prepared by DAA Group. As part of the plan, a sound limiter had been purchased and would be installed to monitor the sound from any amplified music devices. It was accepted that this had only been done recently. However, it was practice of the premises to proactively manage noise levels by monitoring the levels of noise using decibel apps on a mobile phone at various noise-sensitive points around the premises. During the interview, in which the transcript is available on FW09, I discussed the night that the statutory nuisance was witnessed on the 11th of December. Mr Atuanya stated that the premises was open until 23:30 with patrons leaving by midnight. He stated that when he is busy, and he may be in the kitchen or elsewhere in the premises, he doesn't look at the clock. When he comes back out to the front, he has gone over his operating hours. It happens sometimes. I advised him that on that particular night, he was advertising I Love Saturdays party after party with DJ Rafi. And according to his premises licence at that time, on the 11th of December 21, he should have been closed at 23:30 hours with patrons leaving by midnight. He was told that officers witnessed loud music and bass at 00:23 hours, with officers leaving at 00:54 hours with the music still playing and patrons inside. Mr Atuanya advised that it was a friend's birthday and the guy was supposed to shut by midnight, but he wasn't there that night. He doesn't work every Saturday, and because he is not there, the DJs might not know to shut by midnight. He explains that sometimes the manager is busy in the premises and doesn't realise the time. Mr Atuanya also states his advertising until late is to get patrons into the premises, but that he closes at midnight. But sometimes the DJs get carried away, and if he or the manager isn't there to monitor them, they just get carried away, and he believes that's what happened on the 11th of December 2021. I then questioned the night that the Section 80 noise abatement notice was breached on the 27th of March at 00:11 hours. Mr Atuanya stated that he believed the clocks went back, so he thought he had an extra hour to play. The clocks went forward at 1 a.m. If the clocks had gone back, this wouldn't have been until 1 o'clock a.m. and would have no bearing on the time the breach was substantiated. The second breach of the notice on Saturday, the 12th of November 2022, at 23:24 hours, was then discussed. It was explained to Mr Atuanya that officers had been out and made observations and witnessed themselves the heavy bass emanating from his premises. Mr Atuanya states he wasn't at the premises on that night. Again, it was his manager, Nadia. He states that there was a DJ there that night and they would use their own equipment but plug into his speaker, which is wall mounted on the party wall by the entrance. Mr. Ataranya confirms again that he is not using the sound limiter as the basement is not open to the public and is still being refurbished. He states that the sound limiter is fitted to all sound equipment. Mr. Ataranya has maintained throughout the investigation that he has a sound limiter installed in the premises, dating as far back as October 21. During this interview, he admitted that the sound limiter had been fitted 2 weeks prior to his interview on 20th of December 2022. When asked whether he had a certificate for the installation, he stated he did not, as the works had not been completed in the basement, which is where he intends to play music and what his noise impact assessment is based upon. When questioned further, Mr. Ataranya admitted that the entertainment took place on the ground floor restaurant level and the basement was not being used and not open to the public. He stated it would be finished that week with the view to it being open over the Christmas period 2022. I repeatedly highlighted to Mr. Ataranya that throughout his interview he has stated that he is not using the basement, which is what the noise impact assessment is based on. However, he is operating on the ground floor level, so he should consider whether operating on the ground floor level could be or is causing a nuisance and to think about where his speakers are mounted. Statutory nuisance is explained again to Mr. Ataranya and how it is investigated. I also advised him that the council was considering prosecuting him for the breaches of the Section 80 notice. Despite this interview, the council continued to receive calls to its out-of-hours service on the 7th and 14th of January 2023. Although visits were not made on these occasions, the complainant submitted noise app recordings and loud music and bass on both occasions. On the 28th of January 2023, a complainant contacted the council's out-of-hours noise call-out service to request an officer visit to witness loud bass emanating from Lounge 44. Sorry, I just need to check that one. Apologies. So on the 28th of January, officers went out to visit and witness loud music and bass emanating from Lounge 44, the Jollof Lounge. It was witnessed from a neighbouring property at a level that would disturb or prevent sleep. In the officer's opinion, the level of noise emanating from Lounge 44 would constitute a statutory nuisance. It was therefore a third breach of the Section 80 noise notice served. On Friday the 24th of February 23, leading into the early hours of Saturday the 26th of February 2023, a complainant contacted the council's out-of-hours noise call-out service to request an officer to visit. I was the duty officer that evening and loud bass was witnessed from a neighbouring property at a level that was unreasonable. However, on this occasion, family members were asleep in one of the bedrooms, therefore I did not feel it was a breach of the notice on this occasion. My investigation shows that Mr. Ataranya has continued to have regulated entertainment, which is having a detrimental effect on nearby residents and is causing a nuisance. The premises is advertised as a restaurant, bar and grill, however is operated like a nightclub in the later hours of the evening. I would now like to demonstrate the use of the noise app and play you some audio files gathered during the investigation. Are you happy for me to? Sorry about the noise when it turns on. The reason why it is played on a speaker is because laptops and PCs don't pick up the low frequency of the bass. The first recording I'm going to play is from the 12th of November 2022 at 22:40 hours, and it was recorded from the lounge area of the neighbouring property, and officers were present when these recordings were made. That's the first one. The second one is from the 7th of January 2023 at 01:42 hours, recorded from a bedroom. I'd like to stipulate officers were not present during this visit because our service hours had closed. The third recording is from the 28th of January 2023 at 22:56 hours from the lounge, and officers were present.
So they just choose their track, doesn't it? It's going to live. Yeah, they do one to the other. Yeah.
And the last recording is from the 26th of February 2023 at 00:23 hours with officers present. I don't think I've mentioned, but the Noise app is a digital form of a noise diary as opposed to the old paper diaries. So it's sent through a secured network. When a complainant uses it, they push a button. It records 30 seconds of whatever noise we're listening for, and it then comes through to our officers at the council. They have no way of replaying the recordings that they've made, so we have them on file here at the council. It has been repeatedly highlighted throughout the investigation to Mr. Atuanya that although he has a noise impact assessment in place, it doesn't prevent him from causing a statutory nuisance. Mr. Atuanya had the noise impact assessment carried out on the basis he would be operating from the basement of the premises. At the time of these offences, the business was not operating from the basement, which he admitted to in his interview under caution, and this was confirmed during an unannounced visit that was carried out on the 18th of January 2023. It is also worth noting that there were ongoing compliancy issues with the noise impact assessment, which was not discharged until the 24th of March 2023. Mr. Atuanya has continued operating regulated entertainment, even though Condition 8 on his premises licence and Condition 2 of his licence variation had not been met. Mr. Atuanya has not changed the way his premises is operated and has failed to prevent further unreasonable disturbances. During visits and communication with Mr. Atuanya, I'm concerned about his lack of management and concern regarding the nuisance he is causing and has shown disregard to the licensing objectives. Mr. Atuanya has been given ample notice and opportunity to cease causing a statutory noise nuisance. He has been advised of the possible consequences should he continue, and yet has demonstrated in his communications with our service that he does not accept that he is doing anything wrong. He considers himself a victim of malicious and jealous neighbours that do not wish to see him succeed as a business. Mr. Atuanya has been informed throughout the investigation that officers are witnessing the nuisance for themselves and not simply taking the word of a complainant. The evidence is clear and supports that a statutory nuisance exists in this case. Mr. Atuanya reported that he was not at the premises on the occasions officers witnessed a nuisance. His manager, Nadia, was, in fact, present. If that is the case, then there are concerns regarding the overall management of this premises. As we head into the warmer and lighter months, there are concerns regarding the nuisance continuing, with the use of the garden area increasing, which also gives rise to disturbance when not managed correctly. I therefore believe the only actions that will prevent an unreasonable level of disturbance to residents and promote the core licence objective of the prevention of public nuisance is for him to revert to his original operating hours, which were the following. The sale of retail and alcohol Monday to Sunday, 11 till 23:30. Late night refreshment Monday to Sunday until 23:30. And recorded music Monday to Sunday until 23:30. Operating within the basement area only. The opening hours of the premises should be from Monday to Sunday until 23:30. The premises may open outside authorised hours for non-licensable activities subject to planning or any other legislation. Please be advised that this does not prevent a further statutory nuisance occurring. Legal proceedings are being considered for several breaches of the noise abatement notice served under the Section 80 of the Environmental Protection Act 1990. On a last note, it should be highlighted that there haven't been any complaints since the application for the licence review was requested. Thank you.
Thank you. Right, it's the opportunity for the applicant to question the environmental protection team.
No, Chair, I'm going to cover the points relating to the lady's audio in my presentation. I can't really frame it as a question, it's more of a statement.
You're going to leave those till you make your... Yeah. Do colleagues have questions for the licensing team?
No, comprehensive report.
Okay, perhaps you should go through it so that it is a record for the public.
The premises licence was granted to Nizibi Limited on the 3rd of August 2020, of which Mr. Kingsley Atuaya is the director. He is also the designated premises supervisor and as such is responsible for the day-to-day running of the premises and ensuring compliance with the conditions attached to the premises licence and upholding the licensing objectives. A written warning was given to Mr. Atuaya on the 29th of November 2022 following confirmation that there were no door supervisors in attendance on Saturday the 12th of November 2022. Under Section 136 of the Licensing Act 2003, a person commits an offence if he or she carries on a licensable activity on or from the premises, otherwise or in accordance with an authorisation, if he or she knowingly allows a licensable activity to be carried on. A person convicted of such an offence is liable to imprisonment and a term not exceeding 6 months or an unlimited fine or both. An officer from the licensing team, myself, visited with Kent Police on the 3rd of March 2023 at approximately 20:15 hours. At the time, there was only one door supervisor on duty at that time when the visit was made, which is in breach of condition 18 of the licence, which states that there should be 2 SIA registered door supervisors on Friday and Saturdays. We spoke to the door supervisor and he stated that he was the only door supervisor that worked on a Friday night. The police officer and myself went inside the premises where the manager of the premises said that other door supervisor was on his break. When asked when he was due to come back from his break, the manager replied that he'd been delayed in starting work that evening but was en route. The police officer visited again later that evening and confirmed that the other door supervisor was present. The licensing support the application for a review of the premises licence as the licensing DPS has failed to promote the licensing objectives by failing to comply with condition 18 attached to the premises licence on 2 separate occasions.
Can I just ask you, the original licence which was granted was for the use of the ground floor. The use of the basement developed through the issues of noise, or was the original grant to the whole premises?
I believe his intention was to always use the basement area. However, obviously when the restaurant was opened, it was a restaurant with music. However, Mr. Atuanya had planned to use the basement, but it took 18 months to get it refurbished and into a condition where he could open it to the public.
So just to be clear, the licence would have covered both the restaurant and the basement? Thank you.
Yes.
Any questions? Any questions? No? No? Fine.
Ms Budding, you said that the door supervisor told you in March this year that he only worked on a Friday. Could it be possible, as we understand from Mr. Swanyu, that he actually said, I only work Friday nights? Not that he's the only door supervisor working, because he doesn't work Saturdays. They have a different team.
Yes, that is possible, but we do have clarification from Kent Police as well, confirming that we both were led to believe the same thing.
Chair, we understand the second gentleman was late. His wife had just had a baby. He'd seen her in hospital, then went straight to work. The question was, so that for clarity, they do have two door supervisors normally on a Friday and a Saturday. That night, we accept the guy was running late. I just wanted to clarify.
As my colleagues have no questions, then it is for you to... Is he a witness of yours? I'm sorry, that hasn't been, that wasn't made clear to me. Okay, right, did you wish to bring your witness in?
I'm actually going to read a statement from the witness because English isn't his first language, but he will be open to questions once I've read that out. So my witness is Mr. Vlad Dumitru. He lives at 42 High Street, Chatham, which is the neighbouring property to Lounge 44. Mr. Dumitru's statement is the following. Good morning, members of the council hearing. My name is Vlad and I live at 42 High Street, Chatham. I'm here to raise my concerns regarding the noise and breach of licence by my neighbours at the lounge located at 44 High Street. The constant noise from the lounge is ruining my life and my family's life. The noise levels are consistently high, making it impossible to relax, enjoy our own home. The noise often carries late into the night, leaving us feeling fatigued and irritable. The anxiety and stress caused by the constant noise levels are taking their toll on my mental health. Maintaining a healthy work-life balance is difficult when my home life is being disrupted by the lounge's noise. My daughter is also negatively affected by the noise levels. She is a light sleeper and is frequently woken up by the loud music and noise coming from the lounge, causing her to feel anxious and unsettled. This is particularly distressing for her as she is in school at arguably one of the most critical times, and the lack of sleep is hindering her ability to focus and study effectively. As a family, we are experiencing sleep deprivation, negatively impacting our health and quality of life. The constant noise is causing stress and anxiety for all of us, making it difficult to concentrate and focus during the day. This has a detrimental effect on our work and personal lives. Although the lounge has a licence to operate, they are breaching it by staying open beyond their agreed hours, causing significant disturbance to the residents in the area. This is unacceptable and it's affecting our lives in a negative way. If the lounge cannot adhere to their agreed upon hours, they should not be allowed to operate at all. It's time for action to be taken to resolve this issue and ensure the peace and quiet of the residents, is respected. I implore the council members to consider reducing the lounge's operating hours to more sociable times that won't cause a disturbance to the residents in the area. The lounge has already breached their agreed upon hours and it's not fair that they should be allowed to stay open even later than originally planned. In conclusion, the impact that the lounge is having on my family's life and the lives of other residents in the area cannot be ignored. The noise and breach of licence are causing significant disruptions and distress. It's time for the council to take action and ensure that the peace and quiet of the residents are respected. Thank you for your attention.
Can you tell me how many children you have?
Just one.
Just one. And how old is your child?
She will be 10 very soon.
So what time does she normally go to bed?
Normally she can go 8:30, 9, but she couldn't go to she can't sleep in her one bedroom. She comes to our bedroom.
Right. Okay, thank you.
Thank you.
Can you tell me, is this nuisance specifically on Fridays or Saturdays?
Friday
or
and
is
Saturday
it all the week?
No, Friday and Saturday, that is the worst times for us. Sometimes other days, but most of the time Friday and Saturday.
Do you live at first floor level
Yeah,
next to the
next door, yeah.
first floor level next door?
First floor and second floor,
Okay,
yeah. Our bedrooms is in second floor.
okay. Your bedrooms are in the second.
Second
You live on the.
Yeah,
and
the
then your
property
bedrooms.
is first floor and second floor, so it's 2 floors.
Yes.
Yeah.
Okay. Okay. Thank you very much.
Sorry, if I could just clarify. The ground floor level are the shops and the lounge, and then you've got the first floor, which will be, first floor will be lounge area, and there are some bedrooms on the first floor, and then there's it's just one floor, isn't it? Yeah. So the bottom floor is the lounge and the shop, and then above that is the flat.
Does that conclude your case? Yeah. Okay. Right. I think I've now got it right. I think it's your turn.
Chair, as you've heard, Mr. Atwanyu is the director of the licence holding company and he's also the DPS of the premises. I can tell you at this stage that Mr. Atwanyu has sold the restaurant and the new operator will be known as it's a limited company, JMLL Resources Limited. The sale will be completed this coming weekend on the 30th of April. I have got a receipt showing the deposit was paid, the initial payment, and the rest of the payments will be made this coming weekend. So Mr. Atwanyu will cease to be the operator from Sunday. The new operators will take over and we've already been instructed to transfer the licence and vary the DPS to the new operator. I've met one of the directors, not the guy who signed the receipt. The intention is to operate the business initially as a restaurant. I'll update the panel on this part before we talk about Mr. Atwanyu. They're going to operate it as a restaurant while they refurb the basement or finish refurbishing it and take measures necessary to ensure that obviously the mitigation measures are there that deal with the noise impact assessment, etc. Understand that they'll only, so when that's achieved and the noise limiter is up and working, they will only be playing background music on the ground floor level. So this is looking forward to the new operator who will take over literally within 5 days. I understand that having sought the review, the EPT are not seeking revocation of the licence. I think the lady's made that, Ms Wilson's made that quite plain, and are proposing the hours are reduced to the pre-variation hours, 11:30 basically. So on behalf of the new owners, who I'm also instructed to speak for, JMLL Resources, I would urge the subcommittee to consider that when they take control of this venue, literally in a few days, with Mr. Atwanyu stepping back, they want to retain the existing hours to ensure the future viability of Lounge 44 as a restaurant. And it is very important to say this is a restaurant for people of Afro-Caribbean origin. We are supposed to be an inclusive society. We have to cater for everybody, and that includes people from the Afro-Caribbean community who bring so much to our country. We want to see them be able to go somewhere where they can meet with people of their own heritage, enjoy a meal, socialise and listen to the music that they are used to hearing and want to hear. We would say at this stage that the new operators come to this premises with a clean record. They do not and cannot be blamed for what has happened in the past, which we'll come on to shortly. So I suggest that to attribute any blame to them would contravene the rules of natural justice. And this new operator should be given a chance to ensure they can run the restaurant successfully while it's financially viable as an asset to the local area and for people of the African community, and Caribbean community. I understand the new operators would accept revised conditions, for example, that regulated, you can put it on the premises licence rather than rely on planning or on a noise assessment, that regulated entertainment may only take place in the basement. When deregulation ends, obviously we're not talking about the deregulated entertainment, but regulated entertainment would only take place in the basement. Only background music would be played on the ground floor after 11, 2300 hours. A noise limiter shall be installed in the basement through which all amplified music shall be played and which has been set and sealed in conjunction with the environmental protection team. Now, the difference of having it on a noise assessment and having it on the licence, which is where I'm used to seeing such conditions, when I do an application, we put them on the licence. The difference is that breach of a licence condition, of course, is a criminal offence, punishable by 6 months in prison, or up to 6 months in prison, and unlimited fine, and appearing before yourselves to lose your licence. So we would urge you to look at that as a way forward on the licence conditions. Comment has been raised about aspects of planning. As you know, planning, this is a licensing hearing. Planning cannot be considered in a licensing hearing. The Secretary of State's guidance is quite clear on that. Other control regimes should not be duplicated onto licence. So I ask you to disregard any comment relating to planning. That does not mean that Mr. Atwanyu or his successors don't have to comply with it. Of course they do, but it's not a matter to influence the decision today. Mr. Atwanyu accepts, Chair, that there were shortcomings during his operation of Lounge 44. He is deeply sorry for those, and he is remorseful. He took over this restaurant 3 years ago in June 2020. I couldn't think of a worse time possibly for him to have taken it over, and respect his guts in trying to take it over, but obviously that was during COVID and the restrictions of the lockdowns and other restrictions that we had at those times. Afterwards, he's gone straight from that, like many other in hospitality, as we see across the country, into the impact of a cost of living crisis that in nearly 70 years I haven't seen in my lifetime, thank heavens. He suffered periods of mental health issues, stress, as a result of which he can't work there full time. It's too bad for him. He's been to see the doctor and had medication for it. This is the only source of income for Mr. Atwanyu, his wife and children. He's only got 5 days more to carry the responsibility. It seems to me that the issues arising in respect to Lounge 44, Jolliffe Lounge, relate primarily to music-related noise, particularly of the bass-type music. Any allegations of people noise, as I think the officer has said in one of her emails, have not been substantiated. That's people in the garden or people outside. Understand that Mr. Atwanyu and his successors will be closing the garden at 10 o'clock. That won't change and require customers to go inside. So I would suggest that 10 o'clock is not an unreasonable time for a garden. I understand too that excess noise levels from smokers or departing customers have not been established. That could be, if members of the panel felt that was an issue, that could be dealt with by dispersal policy, which we could do for him anyway. It is accepted that African music includes a high level of bass. However, I have to say in the ones that Miss Wilson played, I did hear it in the one on the 12th that she referred to, the 12th of November 2022. On the other three that the gentleman recorded, I could hardly hear it. I've got normal hearing. My partner could hardly hear it. So it's the levels. We're not saying it wasn't there. It's just the level of it. I would not, if that had been playing in my lounge, have gone banging on my neighbours next door. First one, yes, I might have, but the other three, no, I wouldn't. And I'm an ex-licensing officer myself from London Borough, and I've been doing this 18 years. That is not the worst music I've ever heard. As I say, Mr. Atwanyu does accept the abatement notice was served, and he has to comply with it, and that it was breached. He does apologise to Miss Wilson and her colleagues, to the licensing authority, and to yourselves. Some of those breaches you've heard occurred when he was absent because of his health problems. Ms Fadei, the manager, may have been busy and distracted from monitoring the noise levels, but that is not to say they didn't do anything. They did. They undertook regular, they've got the decibel app on his phone and on Ms Fadei's. They go round various points outside, over the road, the garden, outside the next door, and check the decibel level. Obviously, Ms Wilson's right, the decibel levels are very rough level, but when I've had to do this myself as an enforcement officer, I'd look at that and think, that noise is loud, and then obviously if you hear it, you put the two and two together. What we heard on those background apps, if you like, in my opinion, wasn't loud enough to cause a nuisance to the people next door. Bearing in mind, we've got representations from the people who live over the top of this restaurant. They've got 3 children under 5. There's a couple, they've both written in, and they've got the 3 children in the flat above the restaurant. Mr. Otoinu keeps in regular contact with them. They've actually written in to say it doesn't disturb them, it doesn't wake their children. There's a guy at number, I think it's 46, who stays in the property next door. He doesn't hear it. We've got Mr. Ami Jabadai, who is a regular customer. He'll speak to you shortly to support the restaurant. But this, the gentleman is the only resident who's made a complaint. Unfortunately, Miss Fadei couldn't be here because she works elsewhere during the day, in which we won't go into. The licence itself only requires the measures in the noise impact assessment to be implemented. This is the first time I've seen that. Yes, I've seen where policies are referred to, noise management plans, etc., etc. But the condition about the limiter should be on the licence to make it clear. The condition, they've got conditions there to keep the doors and windows closed. That sort of thing should be on the licence. It makes it clearer to the operator what is and what isn't, required. He's now offering, and his successors, I've spoken to Mr. Adwani before we came in here. The new operators are happy to have that condition I've already mentioned. Music in the basement, ground floor after 11, background music only. It's going to be background music at all times on the ground floor, but legally I think we can only impose it after deregulation. And they'll have the noise limiter in the basement to be set in conjunction with the officers and locked away. So it can't be, the DJs will have to play through it and they can't change it. So that's the intentions that the new operators have got. As I say, they have been checking outside, checking at other points to make sure the noise levels were, from both the customers and the music, were not excessive. Obviously this matter occurred over a period of 18 months. Now, Mr. Adwani is quite adamant that from March 22 to the end of September 22, they played no music. I think the first time you played it was on the 31st of September last year. That's when issues may have arisen again. But for the period of March last year to September, they played no music. So what we're saying is any complaints alleged during that time did not come from his restaurant. There is another premises down the road, which I'm not going to mention, other than to say it too has a late licence, and I understand they even have people drinking on the pavement. That's something that could attribute it to noise here, but it wasn't Mr. Adwani's premises during that time. I would also say, with respect to the gentleman, that anyone living in a town centre on a busy high street, in this case next to a restaurant which pre-existed his moving into the property, has to accept there will be some noise disturbance. I've had it myself. I've had a pub as well. And when I moved off opposite the road, this was in Kent, it annoyed me, but you have to accept it. It's a balance. That's what the Licensing Act says. It's a balance between his right to run his business and the gentleman's right to enjoy his premises. It's quite clear in the guidance. That's what it says. And that's what we have to apply. So I would also just comment briefly, if I may, on the door supervisor question. Mr. Atwanu accepts and apologises to you that on the first night that Miss Budding mentioned, the doormen weren't there. That's been dealt with, I believe, by a warning letter. On the second night, I've explained the second door supervisor, we're not condoning it, but the second door supervisor had a reason that he was running late. His wife had just given birth to twins. He should have stayed off and they should have got somebody else, but the agency didn't have anybody. The guy was told to get there as soon as possible. The policeman saw him there later in the time, at the high-risk time, I would suggest, of the evening, which is later when people have been drinking. Now, bear in mind, please, this is a restaurant with a capacity of 35 people on the ground floor, and it will be about 20 in the basement. So we're looking at 55, maybe 10 in the garden. It seems disproportionate to me that a restaurant like this is required, and was required under the previous licence, to have 2 door staff in the first place. The Metropolitan Police scale is 1 per 75, and generally that is accepted across the board. But it's 1 per 75 or part thereof, number of customers. So if you have 76 customers, you have 2 door staff. But for 55, the burden on the operator, is, in my opinion, excessive. I have to mention to you, I'm not comfortable doing it, but Miss Faday has put in a witness statement, which I sent to Mr. DeFazio yesterday. I don't know if you got it, the witness statement from Miss Faday. She's submitted.
Yes, I did.
Yes, I don't want to discuss it in public. If members have seen it, I'm content to rest there. You've seen the allegations made, the comments made. I have advised Mr. Adwani to refer those matters back to the police. It's a police matter. It needs to be dealt with by the police. Any allegation, and I want to say this for the record, any allegation of racist conduct is not acceptable in this country now. I feel strongly about it, and I want to see the matter dealt with by the police. So we're going to take that up with the police. But that is the lady's comments, not mine. That's how she felt, the way she was spoken to. So I leave that to you. So we are concerned that there may be a little more to this than meets the eye. My concerns is for the future of this restaurant, that they are allowed to succeed under the new operator. Mr. Adwani stepping back, with the minimum burden put onto them as a new premises that could be successful. The new operators with positive ideas, no noisy music on the ground floor, noise limiter in the basement, conditions on the licence, but they have asked that you consider allowing them to keep the longer hours, to maintain the viability of the premises, to get customers in there. We have to accept that the Afro-Caribbean community do go out later. So do a lot of our youngsters now. You only got to look at nightclubs. But I know for a fact, having dealt with the premises in East London, they had an African night on Sundays. The guests go out at 10 to 11. You see the ladies arriving all dressed up in their costumes and what have you. And I think you'll bear me out on that. But they go out later and they stay out later. He also gets people that have been to work or whatever from the Afro-Caribbean community want to go out later at night. It's their custom. Not to make a nuisance for other people. Now they know about it. The new operators will address those issues. As I say, people noise can be dealt with by keeping the garden closed at 10 and a dispersal policy. So I would ask you to, when you're making your deliberations, to bear in mind the new operators, that Mr. Adwani's sorry for not getting on with Miss Wilson and sorting out the noise abatement notice, but he won't be there anymore. So I'd ask you to allow the licence to continue with those conditions. Thank you.
Thank you. A few questions. Just a minute, Hazel.
Just have a couple of questions and a couple of points in relation to the evidence given by the licensee's representative. You mentioned about the noise recordings. In your opinion, if you were in your living room, they would not be disturbing. On what basis would you give that judgment? Do you have any experience in noise nuisance enforcement, such as my colleague here, who's got quite a lot of experience in assessing statutory nuisance complaints?
Yes, I was a licensed officer myself for 3 years in Havering. And prior to that, after that, I spent 6 months doing enforcement in St Albans, which included dealing with noise complaints.
Is that from a licensing perspective?
Yes.
Okay, thank you. That's not what I was asking. As you can probably appreciate, noise nuisance enforcement sits with a local authority, with the respective environmental protection teams, who often have lots of training and experience in this area. So I would say from a licensing perspective, you've got that experience, but from a statutory nuisance perspective, you don't. So back to the point on your judgment that it would not be a nuisance in a living room. These complaints, I believe, are in relation to noise in bedrooms. So that argument, from my point of view, is not valid.
Can I come back on that?
I'm just asking you questions. Yeah, so would you consider noise disturbance in a living room would be looked at differently to noise disturbance in a bedroom?
I'll answer it, Chair, on the basis, as I've already said, on the noise complaint, the tapes that gentlemen produced relating to 7th of January, 22nd of January, I think it was, and the 26th of February, we could not, we're sitting here listening to it, we could not hear a noise. It wasn't a noise. If that's the evidence,
with all due respect, the noise app is done from a mobile phone, which is not a noise-sensitive microphone at all. So that will not produce the noise that you would hear when you were inside the property. Not just myself, other officers have been in the property and heard it. We're looking at it preventing sleep, which it does.
Chair, I'm not disputing that the officers witnessed noises, but I'm talking about where the guys put it on an app where you can't hear it, and it wasn't witnessed by the witnesses. That should not be taken into account. Only the events witnessed by the
I've given 4 recordings out of 273 today, and I've picked ones where there were officers present and officers not present, which I made clear. We do not act on the noise app recordings alone, which is why officers go out to visit and witness it. The noise app is used as a tool now when officers are out to make the recording, to also demonstrate what we're hearing when we're there, but it doesn't give the level at which we're hearing it. We also don't look at decibel levels under statutory nuisance legislation. So I think it's invalid what you're saying in terms of it wouldn't disturb you. That's your opinion.
I stand by the comment. We could not hear it when it played.
Sorry, thank you, Chair. I'll just add a couple more questions, if I may. So you mentioned that the licensee carries out sound level checks in the vicinity of the premises using an app on a mobile phone. Can I ask what level you would deem it appropriate to take some kind of action when you did your measurements? On what basis you would take some action?
The planning committee, the planning authority sent me a frequency, which is must be above 42. So I'll always kind of like check it, so it's not up and down 42.
And just following on from that, does your phone give you a frequency analysis that enables you to determine that the noise levels exceed those the levels in those frequencies? Are you able to show us? Because it's very unusual, in my experience as a noise officer and an acoustician, that a mobile phone is able to do a frequency analysis suitable for comparison with a license or a noise impact assessment. A, the microphones are not sensitive enough to do that, and B, they're not necessarily validated for environmental noise measurement. So I would take that with a pinch of salt, that would be an effective tool for doing measurements, for interventions. I did have another question, and I think I've lost it, Chair, so I'll park that one for now. So thank you, I'm finished.
I would just like to ask, obviously you referred to a new operator and they intend to run it the same as Mr. Atawanya has been, correct?
No, I think what we said was that they intend to run it as a restaurant that's certainly on the ground floor. They will want to play music in the basement, hence the offered conditions, but on the ground floor it will be background music only. That's not a club or anything, it's a restaurant. So that's the intent, that's what the director that I met last week has told me.
So what do they intend to do with the basement?
They will be wanting, when they've refurbished it, 'cause I think we've all agreed it needs to be finalised, whatever they're doing down there. The limits are put on and such other measures as may be necessary, because they will get another acoustics report done before they use it, but they want to use the basement. That will be for music.
So just to confirm, today you are stating that that basement is still not in operation and the sound limiter is not working.
The basement is in operation, the sound limiter is working, right? But we don't use it anymore. Because like you just mentioned, I've decided to give up. And for that, I just decided that I'm winding down. And again, I just want to put in something that it's not like we're playing this music in talking about. It seems like it's a nightclub. In African Caribbean restaurants, music is an ambience. People love to eat, enjoy. Okay, sorry. It's not for them to dance to the music. The music is an ambience to them enjoying their food and their meal. Unfortunately, yes, some speakers might be a little bit, the bars might be stronger or more powerful, and that might cause, yeah, we understand that it causes disturbance to neighbors. But I just want to point it out that it's not a nightclub that we're doing. What we're doing is to put music to the ambience of entertaining our guests. So if it's like people saying it's music, it will seems like we're doing a nightclub. It's no nightclub. It's an ambience just to entertain the guests, because this is what most of our customers are accustomed to. That's just what I want to put in there.
Yeah, if I may take liberties, Chair, I've remembered my question. Yeah, I was sitting there thinking. So I've heard some in the representations in against the review that there are no issues with noise, but on another hand, the the licensees agreeing that there have been issues. So I find that sort of a juxtaposition is a bit odd. I just wanted to ask, given that if you thought there was no noise issues associated with the premise, why you didn't appeal the noise abatement notice in the Magistrates' Court, if you feel there were no issues?
Sorry. Yeah, Stuart, I'm not sure that's relevant to this. This has nothing to do with the Section 80 notice or whether or not that was appealed. This is a different arena.
Sorry, I would disagree, because I think it's relevant to the investigations of noise complaints and the evidence given by the applicants that there were no noise issues and there were and there weren't.
These are completely different proceedings. It doesn't relate to the criminal prosecution or the notice, and so those are different.
Thank you. What I would like to say, I disagree.
Okay, fine.
In that case, Chair, I have to say I do agree with your legal officer. This is a civil case, not a criminal case.
We are taking the advice of the legal officer.
Just one last thing, Chair. When we're looking at public nuisance or statutory nuisance, there only has to be one complainant. We don't have to have more than that. When you're looking at who is affected in that particular area,
Is this a question?
it's just an overall synopsis.
Did you get the opportunity to sum up?
Okay, so Mr. Hopkins, you've said that, other neighbours on the other side aren't affected, but they are all people who frequent the premises. And officers have been out and have witnessed the nuisance in another property. And I just wanted to make that clear to you.
That's not a question, Chair.
Hazel, you had a question.
Yeah, my question is actually for the applicant, and it relates to the licensing authority. And we are the licensing authority, and you do hold a license. And I'd like to know, do you understand actually the 4 licensing objectives that your license requires you to adhere to? And if you could, please tell us what they are.
Yes, I do. It's the prevention of public nuisance, prevention of child and prevention of child having been in any harm. Prevention of it's for prevention of public nuisance, public safety, child harm, and what's the last one again? Public nuisance, public safety, child harm, and I'm just trying to get the last one. I'm gonna get the last one, but I know it's sorry, I forgot the last one. It's public nuisance, public safety, prevention of child, and yeah, prevention of this, child safety. Yeah.
I'm happy to help you out. It's the prevention of crime and disorder.
Yeah,
So you've been the licence holder for a long time and you're not quite sure of the objectives, but that's fine. You did mention public nuisance and we recognise that when you required extension of hours, which did come to planning as a licensing issue, but actually it was a planning application which was heard by the licensing subcommittee. So just for clarity, sir, you did get an extension of hours which are limited, and it has conditions on that extension to the license. It isn't sitting alone as a planning application, which I think your advisors seem to think it is. But there is a restriction on that. And the application comes in to maintain the longer hours only for 6 months. So in July of this year, on a specific date, they come to an end. And the reason that it was only for 6 months was because it is written in the papers that there is a concern over this under the licensing condition, which was the licensing condition to prevent public nuisance. So there has been reference to this previously. Now, my concern today is we're here hearing events that have happened over a long period of time with varying degrees of comfort as to whether the basement's in use or not in use. And we're asked to license this till Sunday. And then a new license comes into force on Sunday. So I'm a little confused as to what you're asking us to do. To continue your license till Sunday on extended hours? To continue your license on reduced hours? Or what are you actually asking?
Chair, if I may, I'll answer that for Mr. O'Donoghue. What we're asking you to do, is bearing in mind the changes taking place at the weekend, is to continue the licence for the current hours into the future. That was always the intention of what we were asking. And if I may just comment on your colleague's comments, my understanding was that the planning application was granted for a period of a year, expiring on July 22nd this year, which both Mr. O'Donoghue and the new operators are aware of.
Thank you, Chair. The new licensee, he's saying that he's going to just have background music in the restaurant. Does that mean he's not having loud music?
Thank you, Councillor. My understanding is that, as I said, the ground floor will be limited to background music. The louder music, if you like, the regulated entertainment after 11 o'clock would be in the basement only.
So when it's ready?
Yes, and I think Mr. O'Donoghue answered that when the chair asked. The basement is now. I'll let him tell you.
I've done the basement, but it's like I said, it seems like it's still been a problem. So the new owners who are taken over by Sunday have agreed that they will still
put in more layers of sound-absorbing materials. So that is what he's mentioning, that it will be ready before they now start playing music. So they still want to do more installations just to make sure that they just want to make sure that everything is above board. And then, like he said, the sound limiter will be in conjunction with the environmental protection team to make sure that they don't have the issues I have. That is what they want to do.
Just to be clear, does what is going on or happened in the basement actually meet the requirements of the licence which is in place at the moment, which I understand had conditions as to how the basement should be treated and how the sound would be mitigated? Has that actually been complied with fully?
Have you complied? What the chair's asking you is, have you complied with the noise impact report? Noise impact? Yes.
I've sent it to them.
I can confirm that it has at the end of March. Yes, it was. Yeah.
Okay, thank you. Okay, so could you tell me what is the future, if you know, because I'm asking somebody who's not going to be the licensee, what is going to be the future? Is it going to be a restaurant on both floors, or is it going to be a restaurant on the ground floor with some sort of bar, hangout, whatever area in the basement? What is the future?
Yeah. Chair, Mr. Atwanyu is saying it is going to be a restaurant, definitely on the ground floor. They will have music. And I would imagine it's still going to be a restaurant, isn't it, in the basement? It'll be a restaurant in the basement. Food will be available. But they're going to have music.
Yeah, but the music, that's what we call the music. It's now the DJ will be the basement.
Yes, what I'm asking you is, in a restaurant, you have tables where people sit down. Is that what is going to happen in the basement?
Both floors, yes.
Both floors? Okay.
It's not no virtual drinking. They have to be seated.
Yes. So, as far as the ground floor is concerned, food will be available with background music.
Yes.
But in the basement, food will be available with louder music.
Yes.
Okay, thank you for making that clear. Right, so is there anything you would like to add before I ask Environmental Protection to sum up?
Is there anything? Could Mr. O'May he's a witness, he did make a representation. He just wanted to make a few brief comments. Go on.
Thank you, Chair, and the committee. I'm here in support of the restaurants, keep it opening. With regards to the incidents of the 12th of November, I was at the restaurant, so that's one of the major reasons why I'm here. On that very day, I happened to be alone in the garden, smoking, and I've been on a phone call, and I had an encounter with the complainant, and he was out there on the window videoing me. So I was asking, why are you videoing me? It went on, and we had an argument, and I left him. Sound-wise, I've always had, when it came to my notice that I was having issues with the sound meter, anytime I'm around there, I've got a Bosch certified system on my phone, and I'm always taking in recordings and levels and passing over to him. So I've always not seen the reason why the complainant always makes a complaint with regards to loud music, because once we are out in the back area, the doors are shut, so it's just whoever is out there talking. That's the problem. And from what the lovely lady has said, with regards to being taking recordings, I heard her say that there were people sleeping in the apartment while she was there. So it's quite a funny one.
What's your question? Sorry.
No, not a question, it's just a statement.
Okay, just to be clear, you mentioned the 12th of November.
Yeah.
The child sleeping in, or the people that were asleep when I witnessed was the 26th of February, which I didn't take action on because people were sleeping.
Yeah.
Although I heard it and felt that it was intrusive, I didn't feel that it was a breach of the notice that was in place.
I just wanted to bring that to
Thank you.
yeah.
Can I just, because the garden issue has been raised, can you just clarify, A, how many people are allowed out in that area at any one time?
In the garden.
How many people do you permit to be out there? I presume that's your smoking area, is it?
Yeah, it's a smoking till 10 a.m. Till 10 a.m. So, to be honest, the restaurant is not that a busy restaurant. It's a place that in the smoking area, we might have till 10 a.m. about 8 people maximum at any given time in the garden. 10, it's closed. So from 10 o'clock till maybe 11, it might be me or my staffs or one or two of my staffs, brothers or sisters, because the thing was that ever since this, well, what I know him as is Antonio. I don't know him as Val. That's what I know him as. Started sort of harassing my my manager. She always have to bring people to stay over with her because I'm not always there. So
Can I just say,
Yeah.
what time does the smoking area in the rear garden stop, and how many people are allowed out there at any one time?
Chair, it's
at 10.
close at 10, 10
Yes.
p.m., 2000 hours,
Yeah.
sorry, 2200 hours, and 10 people are allowed out the back.
Okay. Can I just ask you, sir, you have use of your garden, the garden of the property that you live in, you have use of that garden?
Not much, but the noise from the garden is going to our property, especially when we open the windows.
Yeah, okay, thank you.
Vivid chase or
Right, would you like to sum up before I come to environmental protection?
Only to say, Chair, that we are urging you, bearing in mind the change of operation, to give the new operators the best chance, allow the longer hours to remain and impose the conditions, the noise limit, music, live music, if you like, after 11, deregulated, regulated entertainment after 11 in the basement only, ground floor after 11, background music only. In practice, it will be background music all the time, but it's the legality of the 11 o'clock. But leave that with you. That's our position. Thank you.
Thank you. Would you like to sum up?
Now, I appreciate I wasn't aware that there would be a new owner. However, I believe it is the intention to continue running the premises as it is at the moment. I can't say whether it will be a problem in the future. It has been a problem for the last 18 months. The customer, Platt, has not been unreasonable in the times that he has called officers out. It's been late at night when we could demonstrate that it would be preventing sleep. I'm aware that the hours are temporary until July, and you may be wondering why I've called this licensing review now. However, I was still witnessing a problem at the end of February, which is when I put the licensing application in. I don't think the measures have been put in place. I have concerns moving forward. I think although we don't or haven't substantiated any issues in the garden, there has been evidence provided that potentially is there. And I welcome your decision that you make today. Thank you.
Thank you very much. Would you like to leave us now? You can either wait to find out what the decision is, or you can receive it in writing. Okay. thank you very much for waiting. Quite clearly, the panel has had significant discussion on this issue, and what has transpired is that my colleagues and I consider that the licensing objectives in respect of public nuisance have been, over a significant period of time, been breached, and therefore it is our view that the premises should return to the licensing hours as requested by Environmental Protection, which is the sale of the retail of alcohol Monday to Sunday, 11 a.m. to 23:30, late night refreshment Monday to Sunday, 2300 hours to 23:30, recorded music Monday to Sunday, 2300 to 23:30. We understand and have been informed that there is the possibility of a transfer of these premises. However, we can only deal with the matter which is before us today, which was the review which was requested by Environmental Protection. What happens in due course will be an issue for the new owners. Thank you.